Good afternoon, everyone, and welcome to the 30th anniversary of the Edith House Lecture. In honor of Edith Elizabeth House, one of the first female graduates of the University of Georgia School of Law and co-valedictorian of her class, the Edith House Lecture series brings outstanding female legal scholars and practitioners to Athens. I would like to welcome Associate Professor of Law Elizabeth Leonard to introduce our speaker, Judge Edith Jones. Professor Leonard joined the Georgia Law faculty in 2011, and her teaching and research interests include health care financing, healthcare regulation, and public health law. She earned her bachelor's degree from Columbia University and her law degree from the University of Georgia, where she was editor-in-chief of the Georgia Law Review and was inducted into Order of the Coif. It is interesting to note that she clerked for Chief Justice Thomas R. Phillips of the Supreme Court of Texas, as well as for Judge Jacques Wiener, Jacques Wiener, there we go, of the U.S. Court of Appeals for the Fifth Circuit, which is the circuit where today's Edith House speaker, Judge Jones, currently serves. Please welcome Professor Leonard.
Thank you, Michelle, and good afternoon. It's my privilege to introduce the Honorable Edith Holland Jones of the United States Court of Appeals for the Fifth Circuit as the 30th Annual Edith House Lecturer. I have personally admired Judge Jones since the beginning of my legal career, first as a brand new graduate of this law school, serving as a law clerk on the Fifth Circuit, and second as an attorney practicing in the great state of Texas. Judge Jones is a legend in her own time and an inspiration to all members of the bench and bar who strive for the highest standards of excellence and integrity in our profession. Now, I understand that law, in fact, was not Judge Jones's first career choice. Rather, she considered following in her father's footsteps as a physician, but ultimately decided to strike a different path for herself in the law. Well, would that we all could achieve such success with our second choice career. After majoring in economics at Cornell, Judge Jones attended the University of Texas School of Law, where she was a member of the Texas Law Review, was inducted into the Order of the Coif, and received the law school's Outstanding Alumnus Award. She practiced bankruptcy law with the prominent firm of Andrews, Kurth, Campbell, and Jones, where she successfully navigated the Houston good old boy network, which was still a daunting prospect when I practiced 10 years ago, to be named her firm's first female partner. In 1985, President Ronald Reagan appointed Judge Jones to the Fifth Circuit at the tender age of 36, and she served as the court's chief judge from 2006 to 2012. Among a host of other honors and achievements during her tenure on the bench, President George W. Bush appointed Judge Jones to the White House Fellows Commission, Chief Justice William Rehnquist appointed her to the National Bankruptcy Review Commission, and the Garland R. Walker American Inn of Court in Houston, on which she has served since 1998, recently elected her as its president. It is our honor to welcome Judge Jones to the University of Georgia School of Law and to learn from her wisdom and experience in her talk, Why the Constitution Matters and Why Women Should Care. Please join me in welcoming Judge Jones.
Thank you, Professor Leonard. You obviously got inside information somewhere. Thank you very much, Dean White and Emily and Michelle, and thank you all for coming this afternoon. It's a pleasure. It's a real pleasure and honor to be here, not just because the lady for whom this lecture is named shares my name, as does my mother and several relatives and now our little granddaughter, but also because I have erroneously been called a pioneer. I was no pioneer in the law. Although when I made partner, some of the fellows said they had to do it. But the real pioneers were the Edith Houses, and the fact that she was the U.S. attorney in Florida is quite a testament to her perseverance and character, and I'm obviously a beautiful woman in addition, so I'm particularly honored. Let me start by apologizing to the professors here. None of my remarks are meant to be personal. I am going to talk about some theories in constitutional adjudication that sort of drive me bananas. Federal judges, like most federal officials, take an oath to faithfully discharge and perform all of our duties agreeably to the Constitution or since 1990 under the laws and Constitution of the United States. Law professors take no such oath, nor would I ask them to do that. I am astonished, however, with the freedom with which many prominent legal scholars now decry our fundamental law. Most of us, most ordinary Americans, proudly see displays of the United States Constitution, for instance, in the National Archives. It's the longest surviving national constitution in the world. It was the subject of 2 full years of celebration during the bicentennial around 1987. To disparage the Constitution, in my view, is somewhat like waving away the importance of Magna Carta to human freedom and the history of liberty. So in this lecture, I'll begin by quoting what some remarkable professorial complaints about our Constitution have been. I'll respond to them briefly and then explain why the Constitution matters as law. It may not be perfect, and it has undergone significant alteration through amendment and judicial decisions in ways that the framers never dreamed of. But its aim was to undergird a free people's quest for self-governance, equality before the law, and the pursuit of happiness, and it has largely realized that goal. Intellectually undermining the Constitution, I contend, is not only wrong, but ultimately threatens the rule of law and the prosperity and freedom that we have come to expect and that we hope for future generations. What are they saying about our Constitution? Abuse is poured on it in certain academic circles in a way that most laymen, I think, would find shocking. Again, I'm not impugning any individuals, but I will refer to 3 different very recent statements by professors. In December, there was a New York op-ed piece New York Times called "Let's Give Up on the Constitution," where the professor concedes that after teaching con law for almost 40 years, he finally realized how absurd this all is. He asked rhetorically, why should anyone care that revenue-raising bills must originate in the House of Representatives? And why does a grotesquely malapportioned Senate get to decide the nation's fate? The Constitution, he says, was born in constitutional disobedience, has suffered from repeatedly being ignored, and thus arguably forfeited its claim to be obeyed. He advocates starting anew, although with a caveat that out of respect, not obligation, we would want to respect freedoms of speech and religion, equal protection of the laws, and the protection against arbitrary governmental deprivation of life, liberty, or property. Another law professor published a book last year on political obligation. According to the website of the school that touts the book, the professor poses provocative questions. Do we, as United States citizens, have a moral duty to obey the law? Are officials obligated to follow what the Constitution's text meant when ratified, to adhere to precedent, to abide by what the Supreme Court today believes the Constitution means? I am quoting. The professor proposes bold answers that such obligations do not exist. Although citizens should obey some laws entirely and other laws in some instances, he argues that no one has advanced a tenable theory supporting why citizens should obey all the laws all the time. In lieu of the duty to obey the law, he states, all of our norms are on equal footing with the state's laws. A book reviewer, who is also a professor, describes the work as one of the finest contributions to constitutional theory in recent years. A third law professor, claiming that the proper mission of legal theory is explanatory, states in a seminar, quote, I will be blunt about this. The governmental system that has taken shape in the United States is a monstrous failure. Under its aegis, we have plundered the natural environment, killed or maimed countless people in this country and abroad, driven great numbers of others into poverty, and treated a favored few, like those at his conference, to a style of life with comforts checked only with the certain knowledge that things cannot go on this way much longer. I continue quoting. Mostly these miseries flow from our selfish culture, yet our basic law bears some of the blame. We have a constitution that celebrates personal avarice, parochialism, and short-term interest to the exclusion of any sense of the public good. The Constitution is a suicide pact, end quote. Nevertheless, he's not prepared to rewrite it. That would be a daunting starting over process, he says. He retreats to his primary task as a theorist of explaining things as they stand in our own time, leaving for another day the problems we would face at the dawn of a new constitutional order. These quotations reflect an unfortunately too common, in my view, academic mindset among constitutional theorists. They question the legitimacy of the cumbersome structure of government we have. They question citizens' obligation to follow laws or judgments with which they don't agree. They find the Constitution incomplete, failing to guarantee positive rights, and then they pay the ultimate insult. It was the product of framers who were dead white males. This last criticism is particularly ironic given that most of the constitutional theorists are themselves white males. And as noted by the above professor, they are a highly favored few in today's society, far more favored by tenure, economic security, and immunity from paying any price for their views than were our framers. Criticism of the Constitution is not unique in our history among the intellectual class. For the nearly 40 years I have been a lawyer, however, academic theorizing, whether overtly political or not, has attempted to make the Constitution further the aspirations, morality, and normative assumptions identified in faculty break rooms. What these recent quotations suggest, however, is an overt challenge to applying and obeying the Constitution, even our unofficially amended Constitution, as law. To paraphrase one professor I knew rather well, let us unpack these criticisms. What does it mean to say that the Constitution is cumbersome? Cumbersome, according to the critics, generally refers to our national legislative process, the amendment process, and the Electoral College. That legislation is somewhat difficult to pass, and amendments far more difficult, allegedly decreases the government's ability to respond to crises and serve popular needs. But who, observing the size of the federal government today, could believe that the legislative process is ill-equipped for its purposes? Federal legislation may be flawed in myriad ways, but plenty of laws have been passed and continue to further whatever purposes the legislators intended. Thoughtful reflection also refutes the notion that it should be more easily subject to amendment. Our Texas Constitution boasts well over 100 amendments, and nobody would say that it is a better one than the U.S. government's founding document. And many, in fact, would cheer the failure of some recent constitutional amendments like the flag-burning amendment, the parental rights amendment, and even the balanced budget amendment. And finally, as to the Electoral College, the subject of criticism every 4 years, actually only 4 out of 57 presidential elections have turned in any way whatsoever on the Electoral College. Well, what about archaism and obsolescence of our constitutional? There are both common and particularistic concerns expressed in this regard. A particularistic concern, for instance, is that because of advances in technology, a clause like the Fourth Amendment reasonableness test is inadequate to deal with current conditions. This concern seems unfounded. There is much to criticize in Fourth Amendment jurisprudence, but courts are clearly willing to circumscribe unreasonable searches and seizures conducted by emerging technologies. The Kylo case put limits on thermal imaging, and the GPS tracking case recently put limits on that kind of affixing those kinds of devices to automobiles. Nor have the courts been unable to cope with the Bill of Rights ramifications of the communications revolution or novel issues generated by the War on Terror. A broad critique holds that in comparison with our constitutions adopted during the 20th century, ours fails to embody positive rights, for instance, to education, health care, and food and shelter, and that this is disadvantageous. Well, this kind of charge invites a couple of questions. Are the Ten Commandments obsolete and archaic? Are Aristotle or John Locke or Machiavelli archaic or obsolete? A constitution is not a rotary dial telephone. As James Madison explained, what is government itself but the greatest of all reflections on human nature? Is thinking about human nature obsolete, or put otherwise, has human nature changed since 1787? Now, Thomas Jefferson had the eccentric view that the people had the right to rebel and overthrow their government every 20 years or so. But our Constitution has established a republican form that could adapt to changing events while protecting citizens' liberty. We should marvel, not criticize, that the essential framework has endured over 200 years. And in fact, very few constitutional provisions are actually obsolete today. If hypothetically the Constitution were altered to include positive rights, the primary change that I can see would be that they would become litigable under Section 1983. Now, you also have to realize that under the Constitution, the legislature can protect those positive rights. But let's think about them being litigable under Section 1983. Judges would supersede the legislative process in determining these positive rights. The disadvantages and undemocratic nature of such a change are too numerous to identify here. But in comparison with our present system, a judge-driven positive rights regime would be disastrous. Even more telling, in my view, no one can convincingly demonstrate that governments whose constitutions do speak of positive rights are more just than what we have, or that their societies are somehow better. And of course, positive rights notoriously appear in the constitutions of places like Russia that don't pay any attention to them at all. The professor's exasperation with our system expresses a dark vision that the Constitution, beginning with disobedience and the original sin of slavery, written by dead white males, and vague, open-ended clauses that have caused seriously erroneous Supreme Court decisions, is flawed, fatally flawed. And this dark vision has finally led them to the open challenges to obedience to the Constitution and Supreme Court judgments interpreting it. This hypothetical conceptual disobedience is not founded in a specific moral crusade like the abolition movement or the civil rights or women's rights movements, nor are they rebelling against a long train of abuses that led the founding generation to separate from Britain. As will be seen later, the rejection of our constitutional system and the obligation to obey the law lead to dangerous ground, laying the basis for anarchy. For now, I observe how opposed is this vision to that of judges, who have taken an oath to discharge our duties under the Constitution and laws. Against this project of debunking the Constitution, the best medicine is to renew our appreciation for the framers and the ingenuity of their creation. In this case, I refer quite in my own mind to my training in elementary school, where we memorized the preamble to the Constitution, various parts of the Declaration of Independence, and the entire Gettysburg Address. What you learn as a child makes a very deep impression. but it had been inherited from generations of Americans. As early as 1818, Jacob Gideon, the publisher of a new edition of the Federalist Papers, confidently stated, "The Constitution of the United States has had, in the sunshine of peace and in the storm of war, a severe but impartial trial, and it has amply fulfilled the expectations of its friends and completely dissipated the fears of early opponents. In just a quarter century," he continued, "the Constitution had led the people to a condition at once prosperous, commanding, and happy beyond all their expectations. To understand the scope of the framers' achievement, we must consider the crisis they faced upon entering the Constitutional Convention, the tools at their disposal, the goals they shared, and the means they chose to address those goals. From near the end of the American Revolution in 1781, the Articles of Confederation had proven unworkable for the task of nation building. They created a 13-state League of Friendship with little central power. There was neither a national executive nor judiciary. National taxes were hard to impose or collect. Laws adopted by the Continental Congress were not supreme above those of the states and could not be enforced. Foreign diplomacy was executed by states or groups of states acting on parochial interests. The cost of the revolution had been borne by printing money and incurring debt, and the national finances were in a shambles. Citizens of one state could not be assured of justice in the courts of another state. The fledgling nation was threatened by dissensions among the states and imperialist designs of foreign powers on their borders. Amending the Articles to address these problems was unthinkable because of the requirement that all the states would have to consent. Madison, Hamilton, and George Washington were instrumental in organizing the convention that crafted the Constitution during 4 months, from late May to September 1787. But the intellectual groundwork for it had been laid 150 years earlier, beginning with the Americans' experience in local government and colonial assemblies. For much of this time, British power was lenient and far away. The Americans absorbed principles of self-government and the rights of Englishmen. During and after the Revolution, they engaged on a practical level in constitution writing as citizens of each state. Numerous governmental models were designed, reformed, and redesigned as their flaws were exposed. The then new principle of separation of powers among the executive, legislative, and judicial branches was tested. In the absence of checks and balances, however, legislative supremacy led to abuses. The Massachusetts Constitution of 1780, largely written by John Adams and largely still in force today, implemented checks and balances that became the model for other states and the federal Constitution. Scholars George Carey and James McClellan summed up the pre-constitutional experience in this way. Prior to the American Revolution, the term Constitution was commonly understood to refer to fundamental principles on which government is based. Now it was seen as something more, as a written document originating with the people that authorized the establishment of a government with limited powers. For the first time, constitutions were readily seen as distinct from and superior to statutes enacted by legislative assemblies. Constitutions were now entitled to the elevated status of a higher or supreme law because they sprang not from the legislature but from the people, through constitutional conventions creating them and ratifying conventions approving them. This was the political background of the framers. Equally indispensable to their creation of the Constitution was their intellectual and practical experience. These were men of action and men of ideas. Several of them, like Franklin and Hamilton, had risen through hard work and talent, but all understood that freedom offers the opportunity for self-advancement. They knew from personal endeavors the triumphs and difficulties of carrying on commerce or agriculture. The delegates had experienced firsthand the abuses of arbitrary governmental power laid out in the Declaration of Independence. They knew the importance of civil liberties and the danger of abridging free discussion of ideas. They had suffered under partial judges whose first loyalty was to the crown. They paid taxes imposed without their consent, and of course many had engaged in military service during the Revolution. Intellectually as well, the framers were enviably well educated by the standards of any century. Most read Greek and Latin, at least, because classical history and authors were viewed as the timeless and indispensable foundation of civilization. The lawyers understood the development of English law as it had progressed through the struggles among the Crown, Parliament, and the judiciary. Many framers were familiar with the new science of politics that had been developed by Locke and Montesquieu, and with precepts of economics then recently articulated by Adam Smith. James Madison, along with others, had thoroughly and systematically studied republics throughout history in a quest to avert their systemic crises and downfalls. Finally, regardless of their personal religious beliefs, they had imbibed biblical knowledge from infancy. The King James Bible was the common heritage of our people. Against the contemporary canard that they were white, often rich, often slaveholders, and of course men, is the universality of the ideas they espoused. They agreed on the principle that all men are created equal, that they are endowed by their Creator with certain inalienable rights. They believed in the timeless laws of nature and of nature's God. They endeavored to incorporate these principles into the fundamental charter of government. And eventually, the ramifications of their principles animated not only this nation, but became a beacon to the world. Through providence, design, or luck, the framers' intellectual and practical toolkits for drafting a constitution were incomparable. Now, with some notion of the difficulties that faced the new United States and the framers' and a knowledge of the framers' broad vantage point, we can admire and learn from the goals they set for a national government. I recommend the Federalist Papers, which are not exhaustive, but are most comprehensive in explaining and defending the reasons for the constitutional structure. The author's words convey their purposes far better than I might. In Federalist No. 1, Alexander Hamilton said, "It has frequently been remarked that it seems to have been reserved to the people of this country to decide by their conduct and example whether societies of men are really capable or not of establishing good government from reflection and choice, or whether they are forever destined to depend for their political constitutions on accident and force." They knew they were operating in an historical moment, and it was their opportunity to found a government based on human reason. Madison in Federalist 51 explained, "If men were angels, no government would be necessary. If angels were to govern men, neither external nor internal controls on government would be necessary. In framing a government which is to be administered by men over men, the great difficulty lies in this. You must first enable the government to control the governed, and in the next place, oblige it to control itself. The objects of government, simply put, are to make it effective while preventing it from becoming all-powerful." Yet, as they knew, the history of self-governing republics was not enviable. In Federalist No. 9, and in a number of the papers, they review probably the history of 100 of republics that have been documented. And Hamilton said, "The history of the petty republics of Greece and Italy spawns feelings of horror and disgust at the rapid succession of revolutions by which they were kept perpetually vibrating between the extremes of tyranny and anarchy. From such disorders, The advocates of despotism have drawn arguments not only against the form of republican government, but against the very principles of civil liberty. An improved science of politics, he said, however, has offered new and powerful means by which the excellencies of republican government may be retained and its imperfections lessened or avoided. Those new discoveries included checks and balances, separation of powers, courts composed of judges holding office during good behavior, and representation of the people in the legislative bodies. As a consequence, Republican federal government was their choice, a government Lincoln would later describe aptly as of the people, by the people, and for the people. The people were sovereign, but rule by the majority had to be tempted lest it fall into the extremes of tyranny or anarchy. The sovereignty of we the people was the clearest example of the individual freedom the Constitution sought to maintain. The structure must accommodate the powerful interests of co-sovereign states while retaining sufficient central authority to pursue the nation's goals. Military and naval forces were necessary as long as the military was prevented from becoming an internal political force. A prosperous economy had to be nurtured by ensuring the sanctity of contracts, eliminating commercial conflicts between states, protecting intellectual property, and stabilizing the money supply. In retrospect, we too easily take for granted this menu of attributes of a government designed to function efficiently and protect individual liberty. Consider, though, that at the time this structure was revolutionary, and its implementation was fraught with peril. The signers of the Declaration of Independence had pledged their lives, their fortunes, and their sacred honor to overthrow British rule. The bargain the framers were asking the American people to make in ratification was one that not one of them had fully approved. Unlike our present politics, it was the product of good faith but hard-won compromise. Significantly, and with horrible historical repercussions, the best it could do was make temporary peace with the evil of slavery, although many framers hoped and believed slavery would not long endure. In a real sense, the framers risked all again in pressing forward with this Constitution. At last, these insights enable us to appreciate the design of the Constitution. Begin with the preamble, which states all of the attributes that I've mentioned thus far. We, the people of the United States, in order to form a more perfect union, establish justice, ensure the domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. Now, in the interest of time, and because you're all very well educated, I won't go over systematically what you know to be the framework of government that they established to realize these goals. But I think we must highlight the nature of popular representation in the House of Representatives, where elections occur frequently, and the representatives are tied to their constituencies, in particular congressional districts. It is no accident that bills for revenue originate in the House, because they're closer to the people who have to pay the taxes. The president's duties are outlined and limited. Largely, they consist of military and foreign diplomacy, authority, and the obligation to take care to faithfully execute the laws. The independent judiciary is assured in Article 3 by guarantees of life tenure and that compensation will not be diminished. The powers of each branch are interwoven, checked, and balanced to reduce the ability of one power to overrun its legitimate sphere. Madison again explained the reason for checks and balances. The greatest security against a gradual concentration of the several powers in the same department, he said, consists in giving to those who administer each department the necessary constitutional means and personal motives to resist encroachments of the others. The provision for defense must, in this as in all other cases, be made commensurate to the danger of attack. Ambition must be made to counteract ambition. The legislative power also is designed to limit oppressive and unjust majority rule by requiring assent to bills in each house and by the president, and as you know, the amendment process is very difficult. The federal structure was preserved by equal apportionment of the states in the Senate and by imposing only the minimum necessary limits on state self-governance. Now, much of the Federalist Papers responds to the anti-Federalist criticisms of the Constitution. They feared the encroachment on liberty of a national government. They dismissed its necessity and predicted that a national government founded on a Republican model could not survive. As they read history, a stable and enduring republic is possible only over a confined territory with a small population possessing the same interests. Madison responded in Federalist Number 10, the brilliant essay arguing that a geographically extended republic will ameliorate the disease of excessive and destructive factionalism. By distributing power and interests widely, the ability of any faction to work its will as a majority will be reduced, and a greater number of competing factions will counteract each other. Here, as throughout the Constitution, the goal was to protect individual liberty. Number 10 acknowledges the tendency of popular government to degenerate into factions. That is, a number of citizens who are united and actuated by some common impulse of passion or interest, adverse to the rights of other citizens or the community's interests. According to Madison, there are two possible remedies against the mischief of factions: remove the cause or control its effect. But, he said, liberty is to faction what air is to fire. It would be folly to abolish liberty, which is essential to political life because it nourishes faction. The causes of faction are inherent in human nature, in differences of opinions and differing faculties that lead to different rights of property. Some of those qualities cannot be sacrificed without eliminating liberty. Thus, the extended republic was designed to obviate this threat of faction. Preserving liberty was also the concern of the Bill of Rights, which included specific guarantees and the overarching Ninth Amendment. In a book written for the Constitutional Bicentennial, authors Christopher Collier and James Lincoln Collier prefaced their work with a quotation from the Prime Minister William Gladstone, who extolled the Constitution 100 years earlier by saying, "I have always regarded that American Constitution as the most remarkable work known to me in modern times to have been produced by the human intellect at a single stroke, so to speak, in its application to political affairs." The Colliers end their book with a clear-eyed summary of problems that faced the United States in the 1980s and identified what they saw as deficiencies in the constitutional structure. But they did not hesitate in seconding this assessment for four essential reasons. First, Americans wanted a government that was practical and commonsensical, and that is precisely what the founders gave them. The American Constitution was written not by ideologues tied to a theory, but by men with vast experience of politics, and it was drawn up to reflect political realities. Second, the American Constitution has worked because the men who wrote it got human nature right. The Constitution takes for granted that neither the voters nor people in government will always make wise choices or rise above self-interest. The government is made to work not only when good people are powerful, but when it is in the hands of fools, knaves, and ignoramuses. Third, the Constitution permits a government that is strong enough to get things done. Fourth, the Founding Fathers were concerned with the rights of minorities and embedded significant protections against faction. And as a consequence, the Constitution allows free rein to independence, ambition, and the aggressive materialism that is a hallmark of the American character. To their reasons, I would add that because the American Constitution embodies liberty, not theory, not some indeterminate and indefinable liberté, égalité, fraternité, the Supremacy Clause of Article 6 means exactly what it says. The Constitution is the supreme law of the land. And law is a tangible expression of do's and don'ts that must be intelligible to ordinary people. Returning to the professor's criticisms at the outset of these remarks, one must ask whether their visions are as comprehensive, their experiences as compelling, their understanding of human nature as clear, and their love of liberty anywhere near equal to those of our framers. If they do not measure up, then it is difficult to accept dismissive and presumptuous attitude toward a framework that has in fact served the people rather well for over 200 years. Certain inherent inconsistencies reinforce the sense that the critics have largely ideological, transitory, and parochial goals in mind. For one thing, they challenge the indeterminacy of constitutional provisions, but are among the first to exploit indeterminacy to obtain favored results in court. They decry the limits placed on the federal governmental processes, but would have the government press more and more constraints on citizens' liberty. They are quick to suggest that because of our Constitution, some groups exploit other groups, while overlooking that they draw from the largesse of the working public to sustain their contemplative enterprises. They advocate more government intervention in private lives, but they ignore the accretions of power and tendencies toward abuse that come with it. Beyond the question of the critics' goals, and even if the goals were wholly disinterested, is the effect of the professor's teaching on generations of law students. To assert that the Constitution is not worthy of respect, that there is no moral obligation to obey a law or judgment simply because one disagrees, and that the majestic generalities of the Constitution are judicially malleable to achieve any result, ultimately undermines the rule of law. John Adams famously held that a republic must be a government of laws and not of men. The critics' attacks would invert that statement. The acid drip of disparagement on the Constitution and laws in schools that train lawyers, future legislators, and judges cannot be overstated. The rule of law presupposes certain shared criteria. The law must be intelligible to those who have to follow it. Law must apply generally rather than serve special interests, and no one may be above the law. There must be fair procedures to enforce the law in court and elsewhere. And democratic accountability is necessary on the part of the lawmakers and the law itself. This ongoing theoretical criticism of the Constitution breeds disrespect for the fundamental document and laws made in its wake. Deconstructing the language and the text imply that any legal text, be it a property description, contract, or local ordinance, is indeterminate. The intelligibility of the law is forfeited when no clear meaning can be imposed on words. If people come to believe the critics' charge that the Constitution was designed to serve only white propertied males, then even-handed application of the law can be jettisoned for the benefit of the disadvantaged, and fair procedures can be manipulated for the same end. One professor actually conceded the results of these lines of argumentation that say you can selectively follow the constitutional text. He said, quote, "Suppose you said about a decision about abortion, who cares? Who cares what provision of the Constitution I'm interpreting? I think it's correct. Once you say that, someone might say, well, if you didn't care about the text in that case, why do you care about it when I make an argument that conditions in the world require that the president stay on after his term? Why can't we ignore the text again? End quote. As I asked earlier, what would it mean if judges took the constitutional theorists seriously and began to decide cases according to our views of justice rather than the written law? I hasten to add that the American judiciary has not been debased in that way, but there is every likelihood that the protégés of some of today's theorists of constitutional criticism will eventually arrive on the bench, and the rule of law may well be thrown into doubt. We are a people of the law, which expresses the consent of the governed. Substitute the rule of individualistic judges for the rule of law, the arbitrary arrogance of officials who believe they can make up any reason to explain their action rather than be bound by strict rules and procedures, and the result will be just what the framers feared: anarchy or tyranny. Women should be particularly sensitive to the implications of destabilizing our constitutional processes and diminishing the rule of law. In the past 40 years, women have made educational and social progress unimaginable when Edith House graduated from law school. Women now constitute a majority of students in undergraduate education, in medical school and law school. Women have ascended to the highest posts in government and business. As future leaders, women will have to pick up the pieces of a government spinning out of control from cynicism bred by disrespect of the law and lawmakers. That women are not proportionally represented in every line of endeavor means nothing, because we have the dual capacity of engaging in the workaday world and being mothers. Many of us make an honorable and laudable decision to postpone or trade off money-making for the higher professional training of young hearts and souls. In either capacity, we seek present and future stability. Women, in my view, are often special victims of social unrest, falling incomes, and lowered expectations. This is because we are disproportionately called on to care for aged and infirm family members, and sometimes at the sacrifice of personal ambition. Financial crises hit us very hard. We suffer from depression more easily. But even more important than our personal trials is the effect on our children of a declining social structure brought about by governmental erosion. Most women with children hope for nothing better than to see them have satisfaction and opportunities in life. Women are the glue of families. Families are by their nature future-oriented, and the Constitution has been the glue of a society in which families could confidently hope and plan. Without the American Constitution, or with only a disfigured and tarred Constitution, the future can relegate us to history's tragic succession of failed republics. Women need to help preserve the glue of our constitutional order. Thank you.